Hello, everyone, and welcome to our webinar, Leveraging Intellectual Property, Finding Your Core Assets, done in collaboration between Biro Oktroi Roosseno and Catalyst. Today, we have an exciting webinar for you all in terms of IP, and we hope that this webinar will be helpful for all individuals and businesses viewing. We have today 4 speakers with us, and we'll show you in a second. We have Ibu Mikni Mirasanda Nurhadi, who is the director of Biro Oktroi Roosseno in Indonesia, Jakarta. We have Ms. Pratashini Rag, the IP manager and a registered Singapore trademark agent. Ms. Nadia Gautama, who is an IP consultant and patent scientist. And Ms. Melly Jamila, who is the IP consultant and head of substantive department of patents in Indonesia. Our topics that we will cover today on the next slide will cover the basics of IP strategy, a little bit on patent filing and drafting, trademark strategies, and a little bit about Indonesian patent law and practices. We will try to keep on to our time here, and this first speaker to start will be Ms. Pratashini Rag. She will talk about IP strategy, and I will pass on over the speaking to her. Please.
Thank you, Hakim, for the introduction. Good afternoon, everyone. Thank you for joining us today on a rainy Wednesday afternoon. Before I dive into my presentation, I just want to say that today's webinar may be a bit rushed as we do have a little time constraint. And as you may know, IP is a broad topic. So if you have any queries at all, please feel free to raise it at the end of the presentation and we will be pleased to address them. Now, moving on to my presentation, recently we realized that most local companies and startups are starting to be aware of the importance of their intellectual property rights and are actively seeking to protect them. But many struggle to know how to go about with effectively protecting their IP assets. So the main focus of today's webinar would be on IP strategies for some of your key IP assets. Hopefully, at the end of the webinar, you will be wiser on how to best protect and manage your company's IP. Next slide, please. So the first topic we will cover today would be effective IP strategy. The first step in dealing with your IP would be to have in place a business-driven IP strategy, establishing priorities in line with the company's overall strategic priorities. With clear IP strategy in place, a company or startup is able to yield new areas of business and profit by 1, having a competitive advantage, 2, having an added value from these liquid assets, and 3, become an attractive option for investors looking to fund a well-coordinated venture. Next slide, please. To have an effective IP strategy, you would first need to identify the IP assets belonging to your company and determining how to best protect it. It does sound fairly simple, but from my experience, a lot of my previous clients, especially startups, do struggle with this. Basically, when you're working with an invention or technology, there are various information and data that you possess, such as your clinical trials, your lab notes, your product name, your product literature, or even your customer's list. This information or data make up your intangible assets and can be categorized as various types of IP, such as patents, trade secrets, trademark, designs of your product, and copyright. So it is important to know the difference between these IP assets and determine the best protection for it, so as to get the most out of it. And when you're not sure of what could or could not be protected, please always consult an IP professional, because your IP is a valuable asset that is worth investing in. And apart from this, you have to have an effective, to have an effective IP strategy, it is important to first identify the main primary markets or jurisdiction that is crucial to you. And then accordingly plan your finance in a way to strategically file in these jurisdictions. I mean, it is normal to want to conquer the world, but it is also important to be realistic and strategic about it. For those of you who have dealt with IP registrations, you would know that it is an expensive expensive investment to protect your IP by filing with the relevant authorities. So you should have a marketing strategy that goes hand in hand with your IP strategy. And one important consideration when deciding on the primary markets would obviously be your target consumers and the IP regulations in each country. For example, if your product or solution relates to HIV medication, you would target countries that's most affected by HIV infection. Likewise, if if you have a dengue solution, you would target dengue affected countries mostly. So I will end my presentation here and hand it over to Nadia to explain more on patent strategies. Thank you.
Thank you very much for the introduction, Shini. Hello everyone, good afternoon. My name is Nadia Gotama. Today I will be discussing about patent filing and drafting strategy. For this section of the presentation, it will be divided into 4 main parts. So let's start with the first part. Next slide, please. The first part that I would like to discuss about is what kind of due diligence that you need to do before filing a patent application. First thing that you have to do is checking your entitlement to the newly developed technology. For example, if the technology is developed whilst you are working for a certain company, then you have to see whether in your employment agreement there is any agreement that you sign with them stating that the invention actually belongs to the company that employs you. Secondly, you have to determine whether the technology that you develop is patentable. For example, is the technology novel? Is the technology inventive? And is it industrially applicable? And thirdly, you may also want to consider other forms of protection for your particular technology. Other forms of protection can be registered design or trade secret. For medtech-based company and medtech-based technology, I believe that the alternative that you may want to consider is trade secret. Trade secret is great for protected technology that cannot be easily reverse engineered by the competitor. Trade secret can be more interesting than patent, for example, because there is no application to file and the information can be protected indefinitely. However, even at the beginning of your process, you don't necessarily have to find out that whether you want to protect your technology by using trade secret or patent, but it's useful to have a general idea on which option that you want to use. However, based on my experience, the final decision can change a lot after you have discussion with the patent attorney. For example, there was a time when I was working on this patent application for an agricultural composition. At the beginning of the process, I only get information about the composition itself. We don't have any information on how to make the composition. However, during the drafting, we find out that apparently a specific strain of microorganism is needed to prepare this agricultural composition. We then tell the inventor, oh, in that case, you would have to actually have to disclose the particular microorganism that you use in the patent application. When the inventor heard about that, they think that their competitors can just easily obtain the strain of microorganism and use it to make the same composition as the one that they are trying to protect with a patent application. We then tell the client, oh, in that case, it would be quite difficult to enforce the patent because we don't have access to the competitor's factory and we don't know what kind of microorganism that they use. So we don't know whether they actually follow our client's patent exactly. So at that time, we just tell the client, you know what, in that case, you may want to keep your invention as a trade secret instead. Last but not least, another due diligence that you have to do is performing prior art search on your particular technology itself. It is highly recommended that you engage a patent attorney when performing prior art search because the patent attorney may be able to uncover more values and realize that there are other aspects of your technology that is patentable. For example, there was a case when someone asked me to do prior art search only on the method to prepare a hydrogel. But then we figured that look, if the method is new, it's possible that the hydrogel itself is new. So we tell them, shall we just do prior art search on both the method and the product itself? They agree to that, and at the end, we find out that both the product and the method can be patentable. So then we suggest that we draft application for, instead of just method only, we actually draft it on the method and the product itself. Next slide, please, Vernice. So after you have performed the necessary due diligence on your potentially patentable technology, the second part that you need to consider is the patenting strategies. There are three main patenting strategies as shown in the table there. And in terms of cost, offensive filing strategy is the most expensive, whilst defensive publication is the lowest cost. However, please note that each of these strategies has its own consequences. For example, for offensive filing, because with this strategy, you file patent application for any technology that your company make as soon as possible. So by doing so, you can protect. You will have a bigger patent portfolio, and because you have bigger patent portfolio, you can possibly generate more royalties from patent licensing and enforcement. On the other hand, with defensive filing, it's cheaper for the company because you only file patent application for business crucial technology. However, because you file fewer patent application, it's natural that you have smaller patent portfolio when compared to offensive filing, and naturally you will also receive lesser royalty. Defensive publication may be also an interesting option because of its very, very low cost and the fact that you don't need to file any patent application at all. However, you have to be careful when you use this particular strategy. That's because once a company discloses part of its technology with this defensive publication, for example, by filing a paper in a scientific journal, you will not be able to file any other patent application for that particular part of the technology. In reality, it's rare that a company will have just one of the three patenting strategy. It's most likely will be a combination of all the three strategy above. So you may want to consult an IP consultant to determine the patenting strategy that is most suitable for your company. Next slide, please. After performing the due diligence as explained on the first slide and determining your patenting strategy as explained on the second slide, you may also want to engage a patent attorney to draft your patent application. So let's talk about the practical approach for drafting. The first thing you have to be aware of is that you are the expert of the technology. You are trying to convey your technology to someone who has a science or technology background, but they don't know anything about your technology. Therefore, in order to help the drafter better and understand your technology, it's important to inform your drafter about any other prior art that you consider relevant. This is any other prior art on top of the prior art encountered during the prior art search process. This prior art can be any publication or new technology that you or your competitor created. Secondly, it is also useful to define the invention in a problem solution format. For example, the problem may be like a certain disease that you need to, that doesn't have any treatment. Then you can say that your invention is this particular drug that can treat that particular disease. It's useful to do this problem solution approach because besides helping the drafter, by seeing a problem solution approach, it may help the examiner to clearly identify the benefit of the invention during their when they are reviewing the patent application itself. Secondly, you also have to be aware that one major requirement of a patent application is enablement, which means that a skilled person can make or use your invention by merely following the information that's provided in the patent itself. In order to do so, you have to provide at least the same amount of information as when you are writing for a scientific journal. Therefore, you have to provide the first three points that I mentioned there, which is clear you have to provide clear description on how to work the invention. For example, the experimental condition, the equipment used, and many other. And then you have to provide description for abbreviation or symbols, even though they are really well known in your field. And thirdly, if the patented technology is an improvement to a solution that is already available in the marketplace, it's important to provide comparative data. So as I said before, in addition to the patent application must have sufficient information as if it's a paper for a scientific journal. However, you also need to provide 2 additional information. So first of all, if possible, provide substitute for part of your invention. For example, if your invention involves a chemical reaction, let the drafter know of any other compounds or catalysts that can work for such reaction. By doing so, it is useful for you because you may be able to get a bigger scope of protection for your technology, or you may also be able to prevent your competitor from circumventing your patent by simply using the substitute that you are already aware of. Last but not least, please also let the drafter know about any non-working examples that you encountered when you are developing your technology. Example of non-working example can be groups of patients that do not respond to your new drug, or temperature or pressure in which your new product failed to perform. If you do not exclude non-working example in your patent, the patent examiner may conclude that your patent is not sufficiently enabled. In summary, drafting is a very important component in patent application process. An improperly drafted patent may cause you to actually spend a lot more money in the long run. For example, you may have, because the patent is not properly drafted, you may have to respond to multiple objections later on from the patent examiner. Contrastingly, if you have a properly drafted patent, it is a very valuable asset for your company because it provides adequate protection for your technology. Next slide, please. So after you have filed your patent application, it does not mean that your hard work is done. On the contrary, there are other aspects that you have to be considered. In this fourth and final parts, we will discuss those other aspects. One of the most important things to be considered is the non-extendable deadline for your patent application. As you can see in the flow chart here, so most patent applications are filed as an incomplete application or provisional application. And then you have to remember that within 12 months from that provisional application, you would need to file PCT application if you wish to file in multiple jurisdictions, like in multiple countries. And then after that, after you file the PCT application, within 30 to 31 months from the priority date, so this is not the date of the filing of PCT application, but the date of filing of the provisional application, the priority date, you would have to choose certain jurisdiction that you would like to enter via national phase entry. Even if you have a PCT application, but if you do not enter national phase in certain countries, you will not have patent protection from that particular countries. Secondly, there is a cost saving strategy that you may want to consider, which is strategic abandonment. So for example, if you have a patent application or a granted patent of a technology that is no longer useful for business scope, or that is obsolete, you may want to choose to abandon them. You can discuss with your patent attorney on how to abandon your patent application. Last but not least, you may also want to conduct periodic patent meeting with key technology employees and your patent attorney. These meetings are especially useful for growing your patent portfolio, because in this meeting you can identify other potentially patentable technology. All in all, the main takeaway from this section is that after filing your patent application, it is important for you to remain in contact with your patent attorney so that he or she may inform you about any action that you may need to take for your patent application or granted patent itself. Thank you very much for your attention. This slide concludes my presentation regarding patent drafting and patent filing and drafting strategy. To talk about the next topic, I will pass the presentation back to Shini, who will be discussing trademark-related strategies. Thank you.
Thank you, Nadia, for the informative presentation. I will now take you through the next topic, trademark strategies. So a carefully selected and maintained trademark portfolio can be a valuable business asset for healthcare and medical device or technology innovators. Why else do you think big pharmaceutical companies are spending tons of money every year to monitor and maintain their portfolio? Precisely because the more recognition your trademarks gain, the more value they add to your company. Hence, it is important to have a foolproof strategy in managing your trademark portfolio. Generally, the companies that do properly protect their trademarks can be in danger of losing their trademark rights and may encounter serious problems such as it could diminish the company's ability to effectively commercialize its products, it could diminish its value to potential customers and partners, and it could create unnecessary legal risk. So since trademarks are an important business aspect, a comprehensive trademark strategy should be developed and implemented by all business owners. Next slide, please. So in this slide, I have included a list of factors you have to take into account to build an effective trademark strategy. However, due to time constraint, I will only be going through two aspects of an effective trademark strategy. Should you wish to learn more about the other factors, please do not hesitate to approach us after the presentation. Next slide, please. The first aspect I'll deal with today would be due diligence, which is to be done before you actually adopt a trade name or a product name. As much as you do not wish for others to infringe your rights, you should also be careful of infringing others' rights, which may eventually lead into unnecessary and costly legal battles. So obviously, one very important thing to do before adopting a trademark would be to conduct relevant due diligence so as to check and ensure that there are no identical or similar marks being used for similar products in your primary markets. And another important thing to take into account would be the naming of your products or your services too, and not just your company or brand name. At this point, I thought I'll share a personal experience with you. So in my previous firm, a couple of years ago, I worked with a client who ran a short spa. And at one point, they actually did a launch of a new range of drinks named after famous superheroes. Unfortunately, 2 days later, they received a cease and desist letter to take these drinks off their shelves. This was quite embarrassing for them because they actually did a whole range of campaigning and social media reviews. And mind you, this client is in the F&B industry. Whereas companies dealing with medical devices or drugs, the consequences would have been more severe, especially when you have to take into account all the FDA guidelines and other stringent regulations imposed. So the best way to check for identical or similar trademarks would be to consult an IP professional to assist with conducting what we call a full trademark conflict search. For this, we would generally conduct searches on the IP registry's records, we conduct searches online, and we conduct searches on the domain name records. Alternatively, you may conduct your own online use search on Google, for example, but it would most likely not be as comprehensive as the conflict search done by a IP professional. Next slide, please. So the second factor I wanted to discuss about would be preventing misuse of your trademark. Because I realized that many startups don't know much about this aspect of a trademark strategy. A trademark risks losing its value when used by a third party without proper license or permission of the trademark owner. As I mentioned earlier, trademarks are an important business asset, and so companies need to be vigilant about improper and infringing use of their trademarks. The failure to stop infringing uses by third parties can result in the loss or dilution of your trademark rights eventually. One obvious consequence would be that over time, the third party who uses your mark may be able to gain goodwill in your mark and will be able to use your mark freely due to the concept of honest concurrent use. One good example would be the Fox head marks in Singapore. The first F head marks that you can see on the screen belongs to Fox Racing, an American motocross icon. And the second Fox head mark belongs to Fox Streetwear, a local Singaporean company. These both marks coexist now in Singapore, specifically in Class 25. The both parties were involved in various legal battles in the past decade, but Fox Racing wasn't able to stop the local Singaporean company from using this foxhead mark. If only they had been vigilant earlier, they could have avoided this. So next, the generic use of your mark. This happens when your company fails to prevent others from misusing your mark as a generic term. One famous example that I can think of would be a trademark that subsequently lost legal protection in the US by becoming the generic name of a medical product, and that is aspirin. Aspirin was originally filed as a trademark by Bayer AG. So the original name for the pill, which many of you may not know, was actually acetyl salicylic acid. And over time, consumers began referring to it as aspirin instead. I mean, it's a bit of a no-brainer why people actually preferred referring it to aspirin instead of acetyl salicylic acid. But still, diligent trademark policing could have helped aspirin avoid becoming generic and losing its trademark protection. In any event, aspirin is still protected as a trade name in a few countries, including Canada and some states in Europe, but it's declared generic in most countries. I also found some very interesting examples of brand names that lost legal protection by becoming generic over time. For example, Hoover. So when I was studying abroad in UK some time back, my English friends used to say, let's hoover the room or flat. And a few years later, when I started to specialize in IP, it was then I realized that Hoover was actually a US brand name that became generic in most overseas countries. But till today, it's still protected in the US, although it's generically used in most, especially most Commonwealth countries, it's generically used to refer to vacuum cleaners. And also, did you know dry ice was actually trademarked by the Dry Ice Corporation of America in 1925 for what we call a solid form of carbon dioxide. And over time, people just started calling it dry ice. And another interesting example I found was the escalator, which was originally a trademark belonging to Otis Elevator Company. So at that time, there were other producers of what we now know as escalators, but back then they referred to it with various other names such as inclined elevator, motor stairs, and electric stairway, for example. So next slide, please. Yeah, so lastly, if time permits, I thought I would quickly try to cover a bit more on some of the common mistakes made by some of my clients when trying to file their trademark applications by themselves. But since I'm running a little short on time, I won't go through every point in detail. Maybe I will just highlight some of the problematic ones. And if you have any queries at all, please raise it during the Q&A and you can contact us after the webinar. So next slide, please. So recently, in the past 3 to 5 years, I noticed more startups approaching us to put out fires after trying to file the trademark applications by themselves. And I thought it would be helpful to highlight some of these common mistakes so that you will be more aware when you try to file or manage your applications by yourself. And so I've put together these 7 common mistakes, like your 7 deadly sins, for trademark filing in Singapore. Some of the some of the points here are self-explanatory, so I won't elaborate too much on it. But yeah, I noticed that there tend to be more errors when some of my clients file the trademark applications by themselves. And some of these errors are minor, but some errors can actually affect your whole trademark portfolio. Because generally, your local applications or registrations are regarded as your home registrations, which you use to expand into other jurisdictions. So it is quite important that you get these home or base registrations properly done. Also, many don't realize that there are technical aspects to a trademark, as in it has to be distinctive, it has to be distinctive, non-descriptive, and it cannot be similar to existing marks. So sometimes when my clients file it themselves, they do not pick up on some of the problems that their trademark may have. And they only realize it after the registry issues an objection letter. Apart from that, it is also important to file your marks strategically, in the sense that for some marks, it may be better to file it in color, and some marks it's better to file it in black and white, some together with the logo or some sort of design. And for some marks, it may be better to file the logo and the word separately. And there is no one fits all kind of solution for when it comes to trademarks. So, and filing strategically can get a mark the broadest protection possible. So, and yeah, as I said, there's no one rule that fits all, and it is best to generally consult an IP consultant if you're not too sure on how to best file your trademark strategically. And another common mistake I noticed would be some clients actually file for the wrong classes. Classes are goods and service categories. So they actually file for wrong classes, or they file for the correct classes, but miss some other important classes or categories out. Like recently, I had a client who deals with a medical product, and they approached us to assist with expanding their portfolio to other jurisdictions. So they had filed the trademarks in Singapore by themselves, but they missed filing in one important class, and they also failed to file their marks as strategically as possible. So they eventually had to refile some of these marks in Singapore before being able to file their marks abroad. Well, generally, clients approach us or law firms or IP firms when they realize that there's some mistakes, or when they receive office actions, which are actually objection letters from the registry. And as soon as they receive these letters, they kind of blank and they panic, they don't know how to handle it. So they approach us. But unfortunately, some startups, once they receive an objection letter, they tend to just abandon their application because they don't know how to go about doing it, or it may be quite costly for them. And I mean, I'm not sure how aware you are, but generally in most IP firms, a trademark application for one mark in one class would cost about $1,000 plus, but rectifying a mistake or filing response to an objection could set you back by a few $1,000s, depending on the complexity of the matter. And lastly, I realized that a lot of my clients were not aware that there are several government grants available for their IP filings. I mean, especially for startups, right? When finances are quite tight, it would actually make sense to actually try to tap into some of these grants. And especially now with this ongoing pandemic, things have been harder. So I felt that it is good for me to, I thought it would be helpful if I actually raised this and brought awareness that you can actually tap into government grants for your IP filings in Singapore and abroad. So if you're not sure about any of these, or if you have encountered any of these 7 common mistakes, please immediately approach an IP or professional, preferably. And with that, I'm done with trademark strategies. Thank you so much for your time and attention. I will now hand over to my colleague from Indonesia, Ibu Meli.
Yes, thank you, Ms. Shini. Thanks for this opportunity. Now, let me introduce myself. My name is Melly. I'm from Indonesia. And now I will presenting about patent filing and drafting in Indonesia. I will presenting the first part, and then Ibu Migni, Ms. Migni will present the second part. Yes, next slide. Now, I want to explain more about patent system in Indonesia. Indonesia has a first to file rule for obtaining patent and not first to invent. This is a practice at the Indonesian Patent Office. And further, application is now filed by online system only. Previously, before COVID situation, the application was filed electronically and manually, I mean by paper, but now only by online system only. And further, Indonesia participates in ASPEC, ASEAN Patent Examination Cooperation. This is the first regional patent work sharing program among 9 participating ASEAN member states IT offices. This program was launched on June 15, 2009. The purpose of this program is to share search and examination results between the participating offices to allow applicants in participating countries to obtain corresponding patents faster and more efficiently. This program will potentially reduce duplication on the search and examination work done, thereby saving time and efforts. Aspect operates in English language only in all participating IP offices and is free of charge to the applicant at any participating IP offices. However, local search and examination fees at IP offices will still apply. And then Indonesia also participates in PPH, Patent Prosecution Highway with Japan Patent Office. This is a set of initiatives for providing accelerated patent prosecution procedures by sharing information. Thus, a granted patent application in Japan can be used as a reference to amend the corresponding application filed in Indonesia. This procedure subject to fee payment. Yes, next slide. And further, I will explain about what is not considered as invention. This is a new rules in Indonesia, which is enforced from 2016 regarding what is not considered as invention. How to deal with it? We will focus on points D and F since they take more concern from the applicant. D regarding procedure and method, which consists only computer program, and F discovery, i.e. new uses for an existing and or known product, and 2 new forms of existing compound, which do not produce significant or meaningful increases in efficacy, and there are known differences in the chemical structure compounds. Now for point D, if you want to file a patent regarding computer program or any software, we usually suggest to make the computer program in conjunction with a hardware or device. Then it will be acceptable by the Indonesian Patent Office and will be regarded as an invention. And then for point F, number 1, existing products means any products that are still protected by patent. For the new use for an existing and or a known product, we usually suggest to redraft the claim to mention the new function, the new use first. For example, if you find an invention regarding an existing compound, but it has a new use, such as antibiotic, and then we will suggest to redraft the claim to be such as an antibiotic composition comprising an existing compound, blah, blah, blah. This is one of the format acceptable in Indonesia. And for point F, number 2, the strategy how to get a patent of new forms of existing compounds is to be focused on the improvement. The improvement can be an increase in efficacy, an increase in safety, an increase in quality. This kind of improvement should be mentioned in the claim. Then this improvement can make the application acceptable and will be regarded as an invention. Next slide, please. Now we will talk about patentability. This is explaining the grace period in Indonesia. Even invention has been exhibited or announced, then the patent application contains such invention should be filed within 6 months as from the date of the exhibition or the announcement. So if it is has been announced in scientific hearing or other scientific forums. So the invention should be filed as soon as possible. Then next slide. Okay, this is the basic rules in Indonesia. There are 5 categories of inventions that are not eligible for patent. Process or products whose announcement and use or implementation are contrary to applicable laws, religious morality, public order, or decency. And B, method of inspection, methods of treatment, and methods of treatment related to medical field, or methods of surgery practiced on humans and or animals. C, theories and methods in science and mathematics. And D, living things except microorganisms. Or E, essential biological processes for producing plants or animals, except non-biological processes or microbiological processes. We usually found method of treatment claim in the application filed in Indonesia. And then we usually suggest to reformat the claim into the acceptable ones. We usually suggest it to format like compounds for use claims, or similar to that, like a product for specific purposes claims. And thus, such claim will not be subject to this stipulation, and then will be acceptable by Indonesian Patent Office. And then next slide. This is regarding genetic resources and or traditional knowledge. If the invention relates to or originated from genetic resources and or traditional knowledge, it must be clearly and correctly state or declare the origin of the genetic resources and or traditional knowledge in the description of patent application. Otherwise, the application will be rejected. Okay, and this is the end of my presentation. The next slide will be presented by Ms. Mikni. Thank you for your attention. Ms. Mikni, please.
Yeah. Thank you, Ibu Mikni. We are running, actually, we kind of ran out of time. Maybe we have a few questions that came in. So I thought I'll just raise at least one of it, and then the rest will answer it offline. So I think I'll raise this to the Indonesian side. One of the attendees asked this question: what is the advantage of drafting a patent specification through an IP firm in Indonesia compared to asking for assistance directly from the DGIP for local Indonesian patents? So this was one of the questions. Maybe Ibu Mikni or Ibu Meli, one of you can address this.
Actually, yes. For the complete answer, it will be better described in offline. But shortly, if you file a patent and drafting a patent specification through IP firm in Indonesia, the IP firm will assist the applicant or the inventor to find what is novel and what is kind of obvious in his invention in more effective way. So there are so many things the IP firm can help and provide you with the cost efficient, yeah, I mean the reduced cost and efficient for filing in Indonesia. That's the short answer. Actually, the full answer, it will be better described in offline.
Sure. Okay. Thank you, Ibu Meli. We have a few more questions, but I think we'll take it offline. We'll definitely get back to all of these questions because we have overshot the time a bit. Thank you everyone for joining us today at this webinar. We hope and trust that the information provided by our team was helpful. If you have any further information, you can still contact us. We are available. So thank you so much for joining us today. Thank you.
So I just want to note that before we end, Anthony, I'm the community manager. So we have the startup advisory clinic with Biro Oktroi as well. If you are interested, please do check out the Catalyst website and sign up for it so that you can have this opportunity, one-for-one consultation together to know more about IP and to understand more about how they could tailor and strategize the plan to help you better for the startups. So with that, thank you so much, Vero. Thank you, guys. We're gonna end off this session, and yeah, we hope to see you in our next webinar. Thank you.